And that's good. The recording started. I'm pleased to welcome everybody to Regulation Central, this month's episode presented by Polunsky Beitel Green, one of our Chrisman commentary shows. I'm your host, Robbie Chrisman, and as I said to our panelists offline, for bandwidth purposes, I'm going to remain off screen today, but that shouldn't take away from our show at all. Very exciting show today. We're going to talk servicing regulations, what's up with the CFPB and its consent orders, some stuff from Director Chopra's latest rhetoric, what we're hearing from the NAR lawsuit, and if we have time, we'll touch on Basel III and the capital requirements there. But before we start, I do want to say a big thank you to Polunsky Beitel Green for sponsoring today's show. They are the preeminent law firm for residential mortgage lenders. You can check them out at mortgagelaw.com. And let's introduce our panelists. From Polunsky Beitel Green, we have Marty Green, who's a partner there. From Absolute Home Mortgage, we have Matthew VanFossen, the CEO. And from Catton and Temple, we have Brian Levy. Brian, I know you're big into legalese. Do you want to do a disclaimer saying you're not part of Polunsky Beitel Green for our audience here at the start?
I'm not going to read anything, but obviously I'm not associated with Polunsky Beitel Green, and I don't want to create any conflicts of interest just by virtue of appearing here on behalf of Chrisman Commentary, which is really why I'm here. We're not providing legal advice. We're just giving general guidance in any event, but just want to make it clear that there's a separation there.
Well, thank you for saying that. I'm going to go back to you to kind of kick it off here. As I said, we have several topics to address. The first one that I want to get into would be the most recent servicing regulation. So if you could bring the audience up to speed on that, give your opinion, and then maybe rope Marty, and that would be a good start to today's show.
Yeah, so the CFPB recently came out with a proposed regulation with actually a very short time frame to respond. I believe the MBA has responded with a letter at this point. There's a lot of issues with the new regulation, but essentially what the CFPB is trying to do with this new regulation is to just make it much easier for borrowers to get help. I think their lesson from the COVID forbearance era was that they feel like that worked really well. And because it was so easy for borrowers to simply raise their hand and say, I'm in trouble, I would like some kind of forbearance, I would like some help. And, without having to provide a lot of information about their situation in order to get that help. So the regulation is kind of a raise your hand regulation requiring lenders to provide that help just because you asked. So there's a lot of concerns around that. Implementation, the costs that it'll impose on servicers. There's also, by the way, an entire initiative around limited English proficiency as well in servicing, and that unfortunately wasn't particularly well described in this new regulation. It was more like, well, we're thinking of making regulations about LEP, but they didn't really provide what those regulations were. What exactly are you supposed to do in that regard? So a lot of questions there, but that's really, I guess, high-level summary of what we're looking at, and we'll see what kind of responses they have to the various industry commentary. And Marty, maybe you have some thoughts.
Yeah, I thought so. You're absolutely right. I think there's a lot of questions based upon the proposed regulation. I think, as you indicated, I think it's well intended in terms of protections of borrowers, but it may not be very realistic in terms of how it's going to work ultimately from the industry standpoint. I think there's a lot of a lack of clarity in general, and perhaps it's even more so. There has to be some balance between consumer benefit and also some certainty on the industry standpoint if you're going to have people have their loans serviced in a way that has some consistency across the board. And that's one of the problems I think they have. The MBA did write a rather lengthy letter. It was about 28 pages, as I recall, where they outlined a litany of problems with it. And I encourage people to read that letter if they want to understand a little bit more about what the MBA at least identified as pretty glaring problems with what the CFPB is proposing. I think one of the things that they pointed out is that there needs to be certainty when you enter into that process as the lost mit as being requested. There seems to be some lack of clarity even when you start, but even more problematic, I think, is there a lack of clarity as to when you exit it and what you do in terms of other collection aspects of it. So there's a lot of problems, I think, with the regulation as it's proposed. I think there's a substantial question, and I think that this would definitely get litigated if the CFPB was to move forward with it the way that they have proposed it, is whether they have a legal authority even to do some of the things that they've proposed with respect to that. And I think that case would most certainly get litigated. It would most certainly get litigated in the Fifth Circuit because it would probably be brought here in Texas. And that I think just based upon my understanding of what they proposed and looking back at the legal framework for that, I think that they run a substantial risk of losing that litigation if they were to move forward. So I think would be very wise for the CFPB to take a much closer look at this, because I do think it's problematic in terms of how they've proposed it and what they're proposing to do it overall here. And I think it could have more pervasive impact, not only on terms of how servicing is done, but the value of servicing rights, I think, could be impacted very negatively by it. And that's one of the things that the MBA pointed out in their letter to the CFPB about it, is that, and these things have to be considered, because obviously if you have less value in your mortgage servicing rights, that's less revenue for the mortgage company. They've got to make that up somewhere in the process. And so you may see increases across the board in terms of mortgage costs. And that's what's doesn't seem to be really well considered, at least in what I read of the CFPB's proposal and the response of the MBA to it, at least.
Yeah, those are all great points. And the one thing I would add to what you're saying, just for an origination focused audience, is that, this is really servicing regs 2.0. Coming out of the Dodd-Frank era, we had a very extensive servicing reg in the form of a RESPA regulation that came out and addressed the whole dual tracking issue and single point of contact, if you remember these concepts. And those things are still in place. But now this is, again, it's sort of the 2.0 iteration of it to add in even more protections for borrowers who are looking to deal with their situation. And I think the potential for abuse is the concern on the lending side, in addition to just the costs of implementing all that. So there's quite a bit to look at here.
Yeah, the potential for abuse is really enormous. I think I remember back, when you see this in bankruptcy context, where you have serial filers, people who are perpetually in bankruptcy to prevent a foreclosure, and they did that, and that was a strategy that people implemented. Well, this is on steroids based upon what they've proposed so far. I think it's really difficult from a servicer standpoint to see where you ever exit from the lost mit status and move forward with your collection piece of it. And that could be really, really difficult, particularly if you were in a significant downturn, I think.
Yeah.
Yeah, Matt, I'd like your thoughts as the owner of a mortgage company when it comes to this, either how you're preparing for what comes down the pike, or your thoughts is what am I going to do when it comes to my servicing decisions?
Yeah, so I think it's pretty simple, right? We're in the business of collateral. And at any point, if a lender feels that the collateral is not able to be recouped, then the valuation of the mortgages that we're manufacturing go down. And when you look at the industry as a whole right now, it's been going through enough trouble with the cost of or the manufacturing cost of a mortgage being higher than it is or it's ever been. We look at some of the new MBA data saying that, hey, we as the independent mortgage bankers are finally starting to see come out of this. We can't start entering into arenas that we go back to potential rule by enforcement, or we go into arenas where courts are making regulatory determinations for us. If I look at our counterparts on the real estate side, look what they just dealt with the NAR lawsuits on having a court making regulatory determinations. it turns into a mess. So, what I'm looking at is saying, well, one, NBA has been a great representative, but we should be asking for, with the proposed rulemaking, expanded commentary periods. This needs to be gone through because the consumer abuses are true. That can happen. I think about the pandemic a lot now, and what we saw with forbearances. We saw pickup trucks with billboards on the back saying, "Don't make your mortgage payments." For consumers, and consumers see that, and they may not be educated on what that actually means and what the unintended consequences are. What we may be looking at to do to benefit consumers may actually harm them, and it may put them in an adverse financial position, realizing there could be back interest. There are penalizations and back costs to forbearance that need to be recognized. It's got the writing on the wall of what we dealt with the loan mod era post 2008. And we saw a lot of regulatory action come out of the bad actors from the loan mod periods. And some people lost their houses along that way, and they might have been misinformed. And so I think that we have to have a couple of things in mind. One, we always have to have consumers in mind. We do have to make sure that consumer disclosure, consumer education on highly complex issues such as forbearance, such as foreclosure, what to do when your mortgages are behind, it is extremely important. But we also have to take into account that we can't disrupt the total market and the evaluations of mortgage-backed securities, the evaluations of mortgage servicing rights, and we can't, just as the industry is coming out of a very hard time, introduce a new litany of issues.
Marty, I saw you nodding your head there a lot. Where'd your head go?
No, well, one of the things that I was really interested about what Matt said that I thought was very, very important to kind of reiterate has to do with the complexity of what the borrowers communicated. One of the problems I see with the regulation as proposed is that it inundates the borrower with information rather than having a more targeted approach. Because there's an inability of consumers and people in general really to process too much information in a limited period of time. And one of the things the regulation contemplates is you're going to tell the borrower every conceivable option that may be available in terms of a loss MIT. Well, that may not be terribly helpful to a lot of borrowers. They really need to look at the one or two most likely outcomes. And one of the concerns I have when I read the regulation or the proposal was the possibility of you leaving something out and then later the CFPB saying, well, why didn't you tell them about this or why didn't you tell them about that? And so I think it just has a minefield effect from a servicer standpoint that's really, really problematic across the board. And I agree with Matt on one key thing that the CFPB should do is they should reopen the comment period to give people a longer period of time to comment on this, because it is a much could have a very pervasive effect in terms of the industry well beyond the servicing arena. And I think that's something that really needs to be carefully considered. As he says, we have kind of a fragile industry as it is, and this could add to that fragility in a way that is not optimal for consumers as a whole. And that's the other thing I think that the CFPB has simply missed the boat on, is that these kinds of changes, while well-intentioned and may help a few people, are going to cost everybody across the board. And is that cost really worth it at the end of the day when the servicing rules that are in place today work reasonably well? Certainly there are some abuses, and certainly the CFPB has taken action against some of those people who have engaged in abusive servicing practices in the last year or two and even before. So they have tools to kind of address those issues. I think sort of a dramatic changing of what needs to happen here on the servicing arena is pretty ill-advised at this point in the cycle.
Yeah, Marty, I would go on a limb and say the average mortgage professional in this industry, if they were served with the litany of available options in loss mitigation, would probably be confused in the word puzzle that's served to them. And this is what they do as a career. I can only imagine the average consumer trying to digest this without appropriate potential legal counsel representing them or trying to explain this to them. And then if you threw a bilingual curveball into that, there's a lot that could go wrong. And sometimes too much information is not a good thing. So really breaking this down and understanding viable paths, potentially putting proper representation or rights of representation in place. All of this is really important if the true end goal is to have consumer protections.
I agree. I agree. Particularly when you consider that this is a dynamic process. So you talk about giving them every possible option, and at which point do you have to update that if another option becomes available, if the investor has added something else to their guide. So you have it, there's just a lot of moving parts here that the CFPB doesn't seem to recognize, in my view.
It's definitely keeping the post office in business because everything's delivered via U.S. mail. So
yes, indeed.
Marty, I have a quick sidebar for you. In your original answer, you brought up the Fifth Circuit. We talk about a lot of challenges coming through that Fifth Circuit out of Texas. What's the reasoning for this? Does it come down to the judge? Has the Fifth Circuit historically been the place for mortgage challenges? Can you provide some color?
Yeah, the Fifth Circuit is just, the Ninth Circuit's known as the most liberal circuit. The Fifth Circuit is typically known as the most conservative circuit, and the one that would be most skeptical of the powers being granted to the CFPB to do what they're proposing to do here. So I think if you look at the Fifth Circuit was where the challenge to the CFPB's funding mechanism was brought, and some other things there. So there's some reasons for it to be brought there. Plus, you have a number of servicers that are here in the Fifth Circuit that's where their locations are. So there's a likelihood that they would want to bring it even as a home court, and even independently of the Fifth Circuit being probably the most favorable forum for this kind of issue to be resolved. But it's mostly because of the bias of the Fifth Circuit would be toward not finding the power for the CFPB to do some of the sweeping things that they're proposing here in this new servicing rule.
Good to know. Brian, before we move on here, and I know you said at the top, this isn't a show for legal advice, but if you're running a mortgage company, what are prudent ways to go about preparing for any changes out there? What's the best way to think about what's going on when it comes to these regulations?
Wow. If you aren't already positioned for dealing with regulations coming down the pike, you've been sort of, I don't know how you've avoided major problems up until now. I mean, you've got to have a process in place for evaluating new regulations, for a team approach to who isn't going to be impacted. Typically there's an implementation period once things are finalized. Again, this is not a final regulation yet, and there's going to be, I'm guessing, some kind of an implementation period in a final reg, but you'll have to address those things when they're finalized. And to Marty's point, or to your point, there very well could be challenges to regulations today are going to be challenged much more frequently given the current state of administrative law that recently changed with the elimination of Chevron deference. And we've talked about that previously. But I think, you've just got to have a process in place. You've got to deal with systems that have to be able to implement whatever the changes are, whether that's your servicing system in this case, or whether that's your origination system for origination regulations. There's some regulations that are sort of outside of systems, maybe RESPA, Section 8 kind of issues. But that is a much more complicated question for every organization. And how far ahead do you want to be looking into the crystal ball of what might be coming, and how do you want to influence that? And all of those things are very challenging questions that every organization needs to have some process around dealing with.
Well, I think particularly on this one, if you look at the servicing piece of it, the training of your personnel would be right at the top of the list as well, and being prepared for that from a training standpoint. But as Brian points out, I think you're going to see changes to this before it actually gets published in a final form, and then you'll have some lead time after that before it's effective.
Yep, Matt, maybe give us an idea of how you prepare for changes that could potentially be coming, the processes you put in place for the people you have in charge of things.
Well, it's not easy. One, you have to have your ear to the street, definitely. As you know, Robbie, I've served on multiple committees at MBA, been actively involved in the Community Home Lenders Association. My job as the CEO of the company is to understand the vibe of the industry and what's going on, and have my ear to the street of the regulations. I got to then bring that back to my organization. I have to meet with my department heads. I have to meet with, depending on what the regulation is, meet with different factions or different departments. If I'm in FHFA and I hear something coming down the pipe with the GSEs, I'm going to be talking to my underwriting departments, my compliance and QC departments. If I'm seeing stuff out of CFPB, that I'm meeting my compliance managers, right? And adapting, evaluating policies and procedures. A lot of things are entered into my little magic notebook that I have that I keep track of stuff. And when we go into our annual meetings in fourth quarter that look at our policy and procedure evaluations, because every year we have to update our policies and procedures, I'm going back and I'm referencing my notes. This is where the investment in industry advocacy really pays off when you're leading a large-scale independent mortgage banker. You need to know what's going on. Sometimes my staff asks me, Matt, what value do you get going to these conferences, sitting in these roundtables, donating your time? And I say, hey, I look at it as the best offense is actually defense. That, I know what's going on in the industry. I know what these changes are. I can meet and discuss these changes with my peers to understand, what I call compliance and action usage. How do we actually act, and how do we have apply usage of regulatory compliance changes, and what are the other companies doing as well?
So let's move from some of these regulations into enforcement actions. And the CFPB's been busy with consent orders, which for those of you out there that aren't necessarily versed in that, the consent orders, they're intended to give financial institutions reasonable amounts of time to correct their violations and demonstrate ongoing compliance with these regulatory standards. But Brian, maybe set the stage for us. What have recent CFPB consent orders been? I know they've been busy out there.
Yeah, I mean, they've been very active, but they've been active for a while. We haven't seen a tremendous number against the mortgage industry, which I think is because the mortgage industry has already sort of taken its lumps for the most part, coming out of that Dodd-Frank era. There's quite a bit though that in terms of like they're concerned about repeat offenders. If you've sort of been whacked once for something and then you seem to be still having problems with complying with regulations or treating consumers in a fair way. Recently, there was one involving a mortgage lender that does a lot of VA loans and sort of not really properly representing the costs to consumers around those kinds of things. But if you look, most of their consent orders recently involve a lot of consumer harm, if you will. Consumers being misled about the cost. There was just recently this very expensive consent order involving a credit card that basically tied consumers into buying from one company and then charged them all kinds of fees, and was very low balance credit card designed, sort of a subprime credit card. But it seemed like really just kind of a classic financial misrepresentation of what consumers were getting, and that's the kind of thing that you hope the CFPB would go after. But when it comes to consent orders, you have to be careful. We're talking about looking into the future and seeing how to provide guidance. I think when you see something like that one, the credit card, you say, well, yeah, if you treat consumers fairly, you provide, good information, you do your best to comply with the regulations as you understand them, you're probably not going to end up with a consent order for just doing that. But, we aren't seeing the kind of consent orders we previously saw where there was a lot of interpretive issues involving things that you didn't know were bad. All of a sudden, some interpretation of either RESPA or maybe fair lending in a consent order. You thought, well, I didn't think I was doing anything bad, but I got in trouble for it. Yeah. I don't think we see that as much.
Marty?
Yeah, I agree with that, Brian. I think that what you saw with certainly under prior administrations, where we saw, where the CFPB was using the enforcement power to kind of expand what the regulations said rather than actually changing it with the rulemaking process. And certainly the industry complained about that. And I think perhaps that was heard pretty well with respect to it. A couple of things that I thought were interesting about some of the consent orders that really more in the mortgage space was the face servicing case. There were a couple of things that were interesting about that. One is, as Brian indicated, they're very concerned about people who are repeat offenders. And this was one where they had a consent order from 2017 that they had failed to comply with, according to the CFPB. And that so as a result of that, they took more aggressive action with respect to them. They ended up having a $5 million penalty plus $2 million that they had to spend on some computer things to get things where their servicing practices were more in line with what the CFPB thought they should be. And the other thing about that case that I thought was interesting is that the CEO of the company actually is party to it, in the sense that the company is prohibited from paying him compensation if they find that he has not taken appropriate steps to bring them into compliance. So there were some aspects of that case or that consent order that I thought were really interesting. There was also another one involving servicing, and you kind of follow the complaints for the CFPB, if you will. And I think Brian pointed this out, that if there's consumer harm, you're obviously going to see more complaints, and if they have more complaints, that's more likely to end up in the consent order arena. But you had the other one was Sutherland Mortgage Servicing, which was a servicer that was fairly newly created to kind of deal with reverse mortgages, and apparently was not really ready, based upon my reading of it, or at least that's the CFPB's position, that they weren't necessarily ready to service the number of mortgages that they ended up servicing, and did a poor job according to CFPB. And so had some significant fines with respect to that. What I thought was interesting, though, about those two both being servicing is then you fast forward to the new servicing rule, and you think, good gosh, if this is what we saw in terms of enforcement under the existing servicing rule, what would you see under the new one, where the new rule has a lot of more wiggle room for the CFPB to find problems, because it's vague in places and some other areas where it lacks clarity, and there's a lack of certainty as to what the servicer is supposed to do in certain circumstances. So I think that those two consent orders really highlighted to me the dangers of some of the things that the CFPB is proposing with respect to the new servicing rule that they put on the table recently.
I know the next show that we have, which will be just after the middle of October, we'll deal with kind of looking ahead to the election and what we can expect from Republican administration taking over versus a different Democratic administration in the White House. But Marty, when it comes to this CFPB and Rohit Chopra, what is the process leading up to these consent orders? Is there much dialogue out there? Is kind of shoot first and ask questions later? What are companies dealing with?
No, I think by the time you get to a consent order, the company is actually agreeing to it. So they've been engaged for some time, but you do have one of the dangers of consent order, and certainly governing by consent orders, that we've always pointed out as an industry, is that some companies, and particularly right now where you have companies that are particularly vulnerable in terms of not having as much perhaps in reserves as they have in prior markets when the market was more friendly to them, they may have to agree to something just to put it behind them. And so that's why the consent orders to expand the law are so dangerous, because it's not necessarily because they're agreeing to it because they think it's right, but because they feel like they have no choice. They have a gun to their head because they just don't have the resources to fight it anymore. But by the time you get to the consent order stage, there has been a fair amount of engagement between the CFPB and the company. And so it's a fair amount of back and forth and those kinds of things. So it's not like something that happens fairly quickly, at least based on my understanding. Brian, you may have some other experience with that might call that into question. I don't know.
No. I mean, by the time you've entered into a consent order, there has been a significant negotiation. I think that's really the point to highlight about a consent order, is that consent orders do not create law, particularly because they are the result of negotiations. They are not by any means, something that you're supposed to pick up and follow the guidance that's in there. Now, it does give you an indication of what the CFPB might have a problem with. And there's, that's worthy of considering, but some of those interpretations, the lack of clarity of what exactly they did have a problem with. I mean, if you look at that consent order that Freedom entered into a year ago in RESPA, I had a lot of questions about that, wrote one of my mortgage musings about that. I mean, you can't, Richard Cordray, I think, really set a bad example when he told the mortgage industry that if you don't look at my consent orders, it's compliance malpractice. That was his quote. And I thought that was really terrible kind of guidance because, in fact, as it turned out, it would have been compliance malpractice for you to follow that consent order guidance because the PHH case came out and said they got it wrong. So I think that did a disservice to the industry, but it left a mark. And I think compliance people have a real tough time now knowing what is going to have the force of law and what isn't. What do they have to follow? What, it's easy with a law like TRID. You got a checklist, you go through it, you make sure that you do everything in compliance with that law. It's another thing, RESPA and how something is going to be interpreted, or LO comp. Those laws they just don't have the same checklist kind of approach. And these consent orders, these policy statements, advisory opinions, now in a post-Chevron world, I think it makes it much more challenging for the compliance professional to be able to guide the business that they work for. So it's a little more challenging.
Matt, this is just one of many discussions you have. You mentioned your time on these advocacy groups, time at CHLA, running mortgage company. Where does your head go with these consent orders?
So the way I look at it is we're in the third iteration of the CFPB. And, this is probably the most middle ground we've seen the CFPB potentially be, and definitely softer than I would have thought out of the Democratic administration. When you go look back on Cordray and then, how Kathleen handled things, and maybe you can call it version 3.5 if you count Mulvaney in there as well as the interim director. Chopra has made public comments to kind of say that, that they're almost impressed at mortgage lenders and how well we handled the decade that came before and how we adapted, how we complied, and that, we're not directly the target in their eyes that we may have once been. I agree on my co-panelist assessments that, I think Cordray was a pendulum swing to the wrong way for the industry. Rule by enforcement was definitely not a way to handle things. Mortgage lenders have definitely showed that they want to comply. But, as MBA says, bright line guidance is the best way to get us to comply. The gray areas and the ambiguity sometimes in some of the regulations, it doesn't work. So, what rule by enforcement does do is give us at least something to go look at. Can it be our regulatory Bible? No, it cannot be. I do think that if you make a good effort and attempt to be aware, adjust policies, adjust procedures, look at other types of rulings and make tweaks, that the CFPB will not necessarily go through your throat. But these repeat offenders are an issue. If they come back in and they see that you're doing it again, now you have trouble on your hands. So, these things have to be taken into account. When we go look at regulatory actions, though, you can go to the CFPB website and go to their enforcement by the numbers charts, and you can actually go see exactly where we sit. And some of the data might be surprising to you. Obviously, the 2012 to 2016 era is the highest eras of enforcement actions by year. 2013, there was over 55 enforcement actions served. You're talking about 4 or 5 a month at that point. That's a lot. And then, surprisingly, 2020 was almost as much. So the final year of the Trump administration was almost as high as the 2015 year. And then we saw it drop off. Now, could the pandemic have had some things to do with that? Sure. Maybe the regulators were busy. They weren't in office. They were coming back. But we have seen a gradual creep up. But this doesn't mean that it's mortgage industry enforcement. Mortgage lenders are not the only bodies that the CFPB oversees. And I think this is going to be a good segue into our next commentary, Robbie, of how does Director Chopra's recent comments play into all of this? Well, let's talk about not his comments, but his actions over the past, 36 months. These payday lenders, these short-term financing deals, the buy now, pay later, the junk fee comments that we've seen him most recently make, which I think we're going to talk about in the next segment. These are the things that we should be looking at, that, the CFPB has kind of changed focus and said, well, let's see other ways that consumers are getting much more short-term harm. Maybe them getting charged $35 instead of $25 for a deed recording fee isn't the biggest issue here, that we have, cost to cures and stuff like that. The lenders and the secondary market seem to be self-policing. But there's these other areas of consumer harm that we really need to start setting precedents in. So, I think that the current CFPB, I don't want to call it lax on lenders. They definitely haven't been lax, but they have given us enough rope to almost hang ourselves with, that saying, look, we're going to give you a little bit of the benefit of the doubt, but we're still there. We're still going to make sure you're aware we're there, but you may not be exactly in our direct crosshairs.
And Marty, I'll give you last word on this before we get into some of Director Chopra's recent comments.
Yeah, I agree with him that what we'll see from a new administration is really an unknown at this point. But I do think that this administration has, in terms of the regulation that we've seen toward mortgage lenders, has not been unfriendly the way that some people feared it might have been. And as Matt correctly pointed out, I think their focus has been appropriately on other areas where you have more vulnerable consumers, and where they have probably been treated much worse than they could. And so there's more upside, frankly, from the CFPB standpoint of going and addressing those abuses than there is, as Matt correctly points out, going after $10 or $15 here and there that may ultimately, the secondary market does sort of squeeze that out, usually in terms of the compliance pieces of that. So I think that the CFPB is probably appropriately putting their resources where they need to be at this point. But as we see on the servicing side, they still seem to be tilted very, very heavily to the consumer side. And so that's something that perhaps in the next administration, whoever it is, will see that adjust one way or the other. But I think that Matt's assessment that they were in the middle of the road currently is dead on. Just to, if you look at how far to the left that we saw Richard Cordray was. Now, he did come in where there wasn't as much on the regulatory side that they had been adopted yet. So they were still in the rulemaking phase of that. Now we've moved into more of an enforcement phase. And fortunately, we're not in the crosshairs of that. And there's probably a good reason for that. If you go and look at what the CFPB gets in terms of consumer complaints, mortgage is a relatively small percentage of those overall. And the ones they do get tend to be on the servicing side, which may be why we're seeing this in terms of the servicing rule, not as much on the origination side at all.
Very well put. Matt, I'm going to start with you on this kind of next transition here, and then Brian, I'd like you to chime in. But Matt, you used the phrase, Director Chopra has been impressed with lenders, or at least his words have had that intended effect. However, you also said actions speak louder than words. So what comments have caught your eye from him recently? And then let's keep in mind that maybe some of the CFPB's actions are more important than what he says publicly.
So by no means am I trying to quote the director here, so forgive me if something is not recited directly off the top of my head, but two recent commentaries come to mind. One was at the New York Secondary Conference, and the second was, I believe, last Monday at the ICE Stock Exchange meeting that he spoke at. Interesting that both occurred in the state of New York, right, which is also one of the most heavily regulated states in mortgage lending. But he made commentary back in June at the secondary conference that was interesting. I was privileged enough to bear witness to it, where he directly said, "Look, you guys have done a great job. Mortgage lenders as a whole have adapted and adopted to regulatory compliance. It seems that you are adhering and you're self-policing. And, we are not here to be your enemy. We are here to continue to receive feedback. We are here to work with you and serve the greater good of the American consumer." Rather out of context, but that's what I got out of watching him speak. It seemed to be that he's starting to put his focus elsewhere. He was very adamantly speaking about junk fees and what he considers junk fees, seems to be that he's pointing his focus towards the title insurance industries and where settlement costs are, and he wants to see settlement costs getting reduced. And he's definitely got a target on the credit reporting agencies. He made commentary about the need for a potential universal reissue key, which was very interesting. He said something to the extent of, why couldn't the consumer take their free credit report and use it to shop for a mortgage rather than have to pay to get their credit report pulled multiple times when shopping? He said there's got to be a vehicle to do so. He didn't know the way to do that, but he recommended finding a path. And I would go out on a limb and say, as a lender, I agree with that. Like, yeah, there should be a way that a consumer can securely transmit their credit report and make it a way that there's no fraud or they can't edit the report, but to somehow data shop, because, hey, self-servingly as a lender, that would save me a lot of money. And, you go look at the actions of some of the credit reporting agencies over the past couple of years. It's no secret they've increased fees. And they've increased fees on lenders during a time when lenders were really struggling. So you're laying off staff and you're getting a bill increase on the other side, and you're not getting that the credit reports aren't better. Not better credit reports. It's not like you're paying a higher fee to have a service that's substantially better. So you look at those actions and you say, okay, well, isn't that interesting? What he's saying, and then we'll see how he'll act, of whether he's going to have any control, of any power of going after these other parties. When I look at his most recent commentary in New York last week, I thought some of the commentary on AI was very interesting. AI seems to be the new buzzword in the mortgage industry. It's like blockchain in 2019. Nobody knew exactly what it was. They just liked to talk about it a lot. And some of the commentary that I saw he made on AI, I'm particularly going to be focusing on. Something I took note of was his commentary that, hey, an active AI at your company is an act of an individual. Meaning that, let's say you have an AI, or how I took it to mean was, let's say you have an AI chatbot talking to consumers on your website. You better make sure that thing is saying the right stuff, because it's the same thing as one of your loan officers giving inaccurate information to a consumer. An extension of the company's compliance, an extension of the website is an extension of that themselves. So, you're going to look at this and you're going to say, okay, isn't that interesting? Simple stuff that could go to trailing regulations, inherent bias inside of AI. We've seen commentary out of the GSEs about that inside of the appraisal side of the industry. We don't know who's programming this AI, or using a GPT, or using internal. What I see from the fintech sector is the emergence of everybody attempting to use some sort of AI. So, I'm putting my guard up on AI usage. I think AI definitely has a place. We're really trying to use it more in the guideline sector and in how to decompile income. But I have a huge concern now over how my companies are going to be utilizing AI involving anything that's consumer facing or corresponding with consumers, utilizing it inside of call centers, utilizing it inside of robo-dialers, utilizing it inside of chatbots on the website, which may be arguably the kind of best use case of get a lift out of it. I now have a lot of concern if the director is looking at those and may potentially be putting a target on companies' backs that are using it. And the company that comes out and goes, we're the early adopter of all this AI, and we're adopting it more than anybody else, look how efficient we are, maybe is the company that's putting an early target on their back.
Yeah, I think there's a lot of stuff there that you talked about, but I think AI is a good example of something where you have to watch what they say versus what they do, right? And sure, they want to promote AI, they think it's great, but their biggest concern is that there's some kind of fair lending negative impact from AI. And yeah, so that's what they're doing, is they're making it very difficult to utilize AI in the industry unless it's proven to not have disparate impact effects, and which is almost impossible to do. The industry has underwriting guidelines provided by the GSEs that will have a discriminatory effect, whether you want to or not. So that becomes challenging to deal with and to compare. Well, what are you saying in terms of lowering costs? We could use AI to lower our costs. We'd have fewer underwriters, fewer, customer service reps. But if your biggest concern is, well, there might be a disparate impact, we've got these things in opposition. We're going to have trouble lowering costs for everybody and avoiding the disparate impact. And in fact, it's probably going to be proven that there's going to be less disparate impact than humans operating today, but that's not the standard that they're measuring it against. They're not measuring against what we do today. So that's one example of say versus do that I think is troubling. But I will say also, sort of going back to the enforcement question, I think what they say in terms of policy changes, regulatory changes, has been still very aggressive against the mortgage industry. If you read the press releases, if you read the kinds of administrative decisions, policy statements, those are pretty aggressive. But what they've been doing that I think I've been pleased with is their enforcement actions have not been against, just a small operator for a technical kind of issue, the kinds of things you saw during the Cordray era. They're generally going after larger operators or people that are really sort of flouting the rules and not being compliant. So I think from an enforcement perspective, what they've done has been pretty good, but what they've said, maybe not so much.
And
Marty.
Brian, just to build on that really quick, you talk about these consumer-facing chatbots and consumer-facing things and inherent bias. I heard them say, we are in your websites, we are looking, and we are testing. So, that's something that like really threw a flag up for me, like, oh my God, right? You go put a chatbot up and all they have to do is know the right trigger words to get the program bias out of the system. And now they can get you without having to be in an exam. They can go test it themselves.
Yeah.
Marty, last word here before we wrap up.
Yeah, I think the thing about AI is really what everyone sort of talked about. I think where it's best going to be implemented by the industry is probably going to be behind the scenes and maybe not so much consumer facing, although it may be a good intro thing. But trying to have AI do too much of what a loan officer or other people have done is going to be a little bit problematic based upon some of the fair lending concerns that everyone on the panel has sort of already identified, and that it's interesting to me that and this is one of the things I really have a problem with the CFPB is referring to things like title insurance as a junk fee. I mean, that's just crazy to me. Now, I think that there is a case to be made that certainly there are ways to reduce that expense, particularly on a refinance, and maybe it doesn't make sense to do it. But to call it a junk fee is really garbage in my view, just because title insurance companies provide great benefits to people who make claims under those policies have been beneficiaries of that. And it's been something that's been required by the industry for decades, and to suddenly decide that it's a quote junk fee is just kind of stupid in my view. But the CFPB apparently is on a warpath with respect to something. And again, this is really outside their purview of what they're supposed to be doing, in my view, because that's not an abusive thing to require something that's been required for decades. It may be worth suggesting that, is that the right approach, and should we look at alternatives? And from a policy standpoint, yes, maybe that's something we should do, but to call it an abusive practice or a junk fee or something like that it seems to me to be just really, really misguided in my opinion.
Well, I thought it was interesting that in that speech at the ICE conference, he did say one of the things that they were going to look at was the additional costs imposed by the regulatory burden, which I thought, wow, okay, let's see what you come up with there.
Right. What's interesting about it, though, is that, yeah, I would think that would be a way that there could be huge benefits, because you look at the stack of paper that we give to everyone that everyone ignores because no one looks at more than the first 2 pages of it. And it's really, we're giving them so much disclosure, none of it's meaningful. But then on the other side of it, you look at it and you say, well, there's a cost to changing what we're doing that's so huge as well. So I'd love for them to do something on the regulatory burden, but I don't know if we can afford it.
Well, if they could get rid of LL Comp, that would
allow
loan officers to lower their costs, companies to lower their costs. That would be a start.
That would be.
Listen,
for years.
He did mention that they're not, I don't think they're gonna vote for an all-out rulemaking that eliminates it, but they did mention that they would entertain a proposed change on certain provisions of MLO comp. It is not completely off the table. So
I don't hold out any hope. I
Yeah.
have yet to see a regulation repealed in my lifetime.
Right.
Well, great discussion, guys. It seems like I've opened a can of worms there that we can probably continue on the next show, along with potential impacts of the election. And at this point next month, we'll also have some more clarity on kind of the shakeout of the NAR settlement and what that's led to. But for today, appreciate all three of you coming on. I always enjoy talking to each of you respectively. Together, it's even better. And thank you to the audience for tuning in. Big thank you to Polunsky Beitel Green for sponsoring today's show. If you're looking for help on any of the stuff we talked about today, mortgagelaw.com is a great place to start. Guys, thank you very much, and we'll see you all next month.
Appreciate it, guys. Thanks.
Thank you.
Bye, guys.